Okay, great. My name is Kirsten Davis. I am an Associate Professor of Law and Director of Legal Research and Writing at Stetson. And I'm here today as your moderator for the panel on scholarship. I have the joy of introducing three individuals who I consider to be both mentors and in many ways heroes, and after whom I have tried to model my own career. They are certainly creators, innovators, and revolutionaries in our field. And so it's just a real joy to get to introduce them. After I do, we're going to watch a couple of video clips that celebrate scholarship before we talk about the work that goes into producing scholarship. And then we'll turn to each of the speakers, and then we'll have a question and answer period for you. To begin, I want to start with Linda Berger, who many of you already know in this room. Linda has been inspirational to me in terms of her power to see the possibilities in scholarship and to follow that through. Linda is the professor of law here at Mercer. She's also the designer of the program at Thomas Jefferson before she came here. And most notably, she, and at least on my list related to scholarship, she is the founding and current co-editor of J. Allwed, Journal of the Association of Legal Writing Directors, and she's the founder of the SSRN e-Journal on Law and Rhetoric, which is a relatively new endeavor for her and has been highly successful. And much of her work involves thinking about the intersect between the power, between rhetoric and legal writing. And she'll be talking today about the rhetorical context of our scholarship. Linda Edwards, the other Linda, on my left, is now a professor of law at UNLV, Boyd School of Law, and like Linda Berger, I'll keep this straight, she is also the founder of a program, particularly the noteworthy certificate program here at Mercer before she moved on to UNLV. She has always been particularly inspirational to me for her intellectual passion and her ability to transfer that passion to students, particularly through the use of the small group writing sessions in the upper level. Her textbook on legal writing has been influential, and her recent work has been innovative on briefs, metaphor, and myth, and that is coming out soon. Did I lose my microphone? Oh, it's better? Okay, thank you. I wasn't hearing myself as well. And she'll be talking about voice today in legal writing scholarship. And the third person not named Linda, they told me I had to say that, so I did. The third person not named Linda is Terrill Pollman, who is the Ralph Denton Professor of Law and Director of the Lawyering Process Program at UNLV. And like both of the Lindas, she is also a creator and designer of a legal writing program, and not only that, but on the founding faculty at a brand new law school when it was brand new. And she has always been important to me for the inspiration she finds in language, as reflected in her foundational piece with Judy Stinson on the language we use in legal writing, the Tower of Babel, Building a Tower of Babel article, and her ability to recognize others and their scholarship as evidenced by her work with Linda Edwards, the piece that compiled all of the various work that we've done in scholarship as a community that came out in the Legal Writing Institute. And if I didn't mention it, Terry will be talking about the audience of our scholarship today. So I think I said it backwards when we started. We're going to watch a couple of video clips about acknowledging how difficult it is to do scholarship before we get to the talk on how rewarding it is to do scholarship. I knew I said it backwards, so let me get it. Did I say it right?
So I will play those two clips for us.
Peu m'importe comment il je n'exigue pas Tomber en pleine il n'a pas besoin d'être grand lumière, car le cinéma n'y passe rien.
To begin, how to start. I'm hungry. Coffee help me think. But I should write something first, then reward myself with coffee. Coffee and a muffin. Okay, so I need to establish the themes. Maybe banana nut. We open on State Road 29. A battered white van speeds along, making a sharp, skinny right into the Fakahachi Strand State Preserve. The driver of the van is a skinny man with no front teeth. This is John LaRoche. I need a break.
All right, so that's about as funny as it's going to get. Those of you students who are wondering about what legal writing teachers laugh about, that's the kind of stuff that we laugh about. So we're the scholarship panel, and I'm going to warn you, use a number of mixed metaphors today. There'll be a quiz at the end of the presentation about exactly which metaphors were the most effective, because we're trying on a number of them to figure out which ones fit the best. We're trying them on as if they are a new suit of clothes. So our goal here today is to try to observe the 25th anniversary of the Legal Writing Institute by suggesting that legal writing professors as a group are entering the third generation of legal writing scholarship. That's metaphor number one, third generation of legal writing scholarship. According to this story of legal writing scholarship, in the first generation, legal writing professors talked about whether or not they should be doing scholarship at all or whether they should just be doing teaching. And if they were doing scholarship at all, they talked about whether or not it should just be purely practical scholarship or whether it should be something more theoretical than that. In the second generation, according to this story that we're telling about legal writing scholarship, people, including two of the people up here on the podium and a number of other people, including Michael Smith, started to talk about the kinds of scholarship that we ought to be doing. They defined a number of different kinds of scholarship and suggested that some of those would be better for the development of the discipline than others. In the third generation of legal writing scholarship, our proposal is that we should find a rubric that allows us to integrate all aspects of our professional lives, that is, teaching, scholarship, and service, and also allow us to engage more fully with outside communities of various kinds. We're going to sketch that out to some extent in the rest of this. So the first thing we're going to suggest is that an examination of our own history as well as an examination of the history of other disciplines. Chris started some of that earlier today, and I'm probably not going to do much more than he did, but an examination of that history will tell us a little bit about where we've been and tell us a lot more, we hope, about where we're going. After that, we're going to propose some reasons about why we write and why we should be engaged in conversations with one another about the ideas in our scholarship, rather than continuing to talk about whether we should write and what we should write, but to actually engage in conversations about what the context is, or the substance or the content of the scholarship that we have produced. And third, and with a nod to James Boyd White, which we always have to make a little nod to James Boyd White, we think that in this way we will begin to address the question of what kind of rhetorical community we're building with our scholarship, what kind of persons are speaking, and to what kind of persons are they speaking. So both who are we presenting ourselves as, and who are our audiences. We probably will not explicitly acknowledge these things today, but we do think there are some dangers with each of these endeavors, but we also think that this is the kind of danger that a maturing discipline should engage in, and so we're going to hope that we're beginning a conversation now. I am going to skip over. I was going to talk a little bit about the development of our sister disciplines of composition, English, the split between speech and rhetoric, the split between composition and literature. But I think Chris really previewed that, and I'm not going to talk about it today, except to say, keep in mind that reading is always, in the academy, viewed as being more important. Interpretation, criticism, analysis is always viewed as being more important than composition and writing and teaching how to do things. And that's going to be important when I get to the vision that we're going to sketch out in a minute. From the outsider's perspective, and that's kind of the perspective I'm taking here on looking at the development of scholarship over the last 25 years, there's a contemporary rhetorician named Bell Hooks who says that the way that you can see the most is to look from the margins so that you can see from the outside in and from the inside out. So I'm kind of trying to take an outsider's view on this. From the outside point of view, legal writing scholarship started with what I'm going to call step one. After step one, that's metaphor number 2, I think, so far. Step one was when it was first discovered that lawyers can't write. That apparently happened shortly after lawyers started writing. And in that step, the first, Jim Elkins at, where are we at? Did a bibliography that was published about 15 years ago, in which he's traced the development of legal writing scholarship. The first article that he has in his tracing was a 1921 article called Defects in the Written Style of Lawyers. The next article in his bibliography was in 1948, and this was by Harry Calvin, who described the University of Chicago Law School training program in research and exposition. So step one was descriptions of curricula and programs to help lawyers learn how to write. A couple of my favorites during that period, and I know some of you have come across these before, were published in the 1970s. One was a low-cost legal writing program, the Wisconsin Experience, topped by legal writing and moot court at almost no cost, the Kentucky Experience. They're not really my favorites, but I thought I would mention them. After step one came something that I'm going to call leap one. Metaphor number 4, Ruth Ann?
Are we talking about all the inherited ones?
Oh, yeah, I don't know. I think we'll just stop keeping track. So leap one was finding a voice that would allow us to talk about our teaching. And that finding of a voice came, I think, primarily from English studies and composition. And it came from the legal writing teachers who had come out of those disciplines and then applied those disciplines, English studies and composition primarily, to the teaching of legal writing. There were a number of seminal articles in that area in Leap 1, which is where we found this voice in these other disciplines, and we applied it to what we were doing. Many of those influential authors are in the room today. I'm going to mention a couple who are not in the room today, just because I think that these articles also deserve to be in this Leap 1 category. One is one that you all are very familiar with, Terry Phelps' 1986 article, The New Legal Rhetoric, where she proposed that composition theory could give us a substantive pedagogy for teaching legal writing. This is, I think, considered by many people to be one of the seminal articles in using composition theory to teach and to looking outside of ourselves to find a theory that would help our teaching. A related article in 1993 was the Elizabeth Fagins and Molly Falk article Against the Tyranny of Paraphrase, where they brought in not just composition theory, but literature theory or literary theory, and started to talk, I think for the first time that I recognized, about reading and interpretation and how that was an essential first step before you got to composition. So that's leap 1, finding a voice outside of ourselves that would allow us to talk about our teaching. Then came leap 2. Leap 2 was building a room of our own. And that's the room that was built by the Legal Writing Institute. So it started with the establishment of the Legal Writing Institute, which you all heard about this morning. That was continued with the establishment of the Journal of Legal Writing Institute and Chris Rideout's efforts in that regard. The first issue of the Journal of the Legal Writing Institute, published in 1991, included articles by 3 people who were rhetoric and composition scholars, as well as an article about the first survey of the field. So this was, it seems to me, very instrumental in building our own place where we're going to be able to talk amongst ourselves about how to teach writing. And that seems to me to have been a major leap in our development as a discipline. In addition to the founding of the Institute and the journal, we also started at that period the biennial conferences. Basically also we're doing much the same thing, building the discipline by allowing us to talk to each other about theories that would help us with the teaching of writing. And I have to mention that around this same time, Terry Phelps and Linda Edwards started the Legal Discourse Colloquia at Notre Dame, which helped a number of us begin to do our scholarship. So we could start talking about our scholarship as well as about our teaching. We could find some theories that we could apply to our scholarship, and that seemed to me to be also part of this leap. Leap 2. Leap 3 is the movement outside of ourselves, and I'm calling this Other Voices, Other Rooms, going along with my Finding a Voice, building a room of our own. Now we're moving to Other Voices, Other Rooms. Other Voices, Other Rooms, I'm sure some of you know, is a book by Truman Capote, and some of you, very few of you, know that it's also a CD by a singer named Nancy Griffin. In Other Voices, Other Rooms, we began to look outside of the disciplines we had already started to look at. So we were no longer looking just at composition and its kind of neighbor rhetoric. We were looking at literary theory, we began looking at linguistics, we began looking at cognitive theory, we began looking at social science, we began looking at feminist theory. So we brought in other disciplines to help us in our scholarship. We also started looking at other subject matters than our teaching to do scholarship about. So this was the beginning, I think, of the movement towards writing about substance or the practices of legal writing, which to me are sort of the same thing in many ways. We started talking about the substance of legal writing, and we also started communicating with audiences outside ourselves. So we're not just talking about teaching anymore, and we're not just talking about pedagogy anymore, but we're communicating about the study and the practice of professional legal writing to a number of different audiences. And in addition to J. Allwood, which is the journal that I edit and whose goal really is to connect with practitioner audiences, there are a number of other things along those lines that I think exemplify Other Voices, Other Rooms. And Laura mentioned this morning, I hadn't really thought about it before, but the Appeal Conference, I think, is a way to bring in other voices and to move ourselves outside into other rooms. The Applied Legal Storytelling Conference is another way to bring in other voices in other rooms. The Legal Persuasion Conference last year, the Law and Rhetoric Conference that Terry Phelps has done, all of those, I think, are the ways that we can now start engaging more with other disciplines and other audiences, and that to me seems to be leap 3 into scholarship. So, where do we go from here? I'm going to suggest, and this is, I'm not saying this is the only thing we should do, because if you have other voices in other rooms, there should be a whole lot of things that we should do. But I'm going to suggest that for many of us, if we do scholarship that focuses on what I'm calling legal rhetoric, and I'll tell you what I mean by legal rhetoric, that will allow us to integrate our teaching, our scholarship, and our service in a really terrific way that will help most of us, I think, advance professionally as well as personally. And it also will force us to engage with other communities than our own, as well as communicating amongst ourselves. So by legal rhetoric, by focusing our scholarship on legal rhetoric, what I'm currently defining that as is the study and the practice of interpreting, imagining, and composing effective legal arguments. So it's not just texts, it's not just reading and interpreting them, it's not just composing them, it's also imagining arguments, and it's the whole process that starts with analysis and interpretation and ends up with composition of a legal argument, whether it's written or not. I'm trying not to confine this just to text. Why is this a good time, and why is rhetoric a good thing, and why are we the right people to do legal rhetoric? Why Law Is Rhetoric? Because since the time of Aristotle and the Sophists, law and rhetoric have been inextricably intertwined. Why law and rhetoric? Because rhetoric empowers the outsiders, and I think that's one of the values that Chris talks about. It's only the outsiders who really need to have rhetoric. It's not the people in power who need to have rhetoric, so I think rhetoric is good from that point of view. I think rhetoric is also natural for us as legal writing professors because of what we do as rhetoricians every day in the classroom and also in our scholarship. More than anyone else in the academy, I think what we teach is legal rhetoric. We teach people to interpret cases and statutes. We teach people to criticize opinions and briefs. We teach people to articulate rules. We teach people to create and invent arguments. We teach people to do the parts of rhetoric that I'm not so crazy about, arrangement and style, as well as imagination and invention. So we are legal rhetoricians, I think, in the classroom as well as in our scholarship every day. In addition to that, I think that the things that we do in the legal writing classroom make us confront some of the really critical issues that you have to confront if you really want to teach and do scholarship about legal rhetoric. One of those issues is the issue that Peter Brooks has brought up, which is what about the John Yoo and the torture memo? Isn't he just a really good law student? Isn't the torture memo just exactly what we've been teaching our students to do in terms of manipulating and using the language? So I think that's one of the questions that if we are serious about teaching and using legal rhetoric, that's one of the questions that we would have to confront in the classroom. I think that our classroom is the place where those questions should be confronted. The other question that occurs to me at the moment that legal rhetoric would force us to confront is the question of personal voice or some sort of voice. And this is the question James Boyd White worries about, that in much of legal writing, nobody is at home. We are basically teaching people to not have a personal voice, but to adopt the cultures and the norms and the practices of the law. And what does that do to a student? What does that do to the students, the rest of the student's life? And is that a good thing or is that a bad thing? Is it just part of the acculturation process? Or is there something else we can do about it? Why now? Why law and rhetoric now? Because formalism is dead. Although no one has told the U.S. Senate that formalism is dead. Formalism is the view that the judges just act like umpires and administer the rules, that the judge acts as a machine and can just decide what the outcome should be once the judge figures out what the rules are. Except for the U.S. Supreme Court confirmation hearings and law school exams, formalism is dead. In law school exams, you better believe the rules determine the outcome. And you better not write on the law school exam that it all depends on whether or not the judge is from a particular political persuasion or not. The fact that formalism is dead, I think, leaves traditional legal scholarship with very little to do. Because traditional legal scholarship deals with precise analysis of legal rules. If formalism really is dead, the legal rules really are not the way that cases are determined, and so you really don't have that much to do in traditional legal scholarship. The alternative that traditional legal scholarship has currently come up with is this deeply cynical view of realism, which is that judges decide everything based on politics and attitudes and personal preferences. And now all the scholarship is about empirical studies showing that that's what judges do. Well, that doesn't also seem like much fun to me. So the reason why I think rhetoric now is a good slogan that we should adopt is because formalism is dead, realism is deeply cynical, I don't want to deal with that. Rhetoric allows me, my students, and lawyers to have an impact. If you think of the law as working through a rhetorical process, then I've got something to do. If you think of the law as being all determined by the rules or all determined by power, I really can't affect the outcome. I have nothing to do. So this, to me, makes rhetoric a deeply attractive way to go about doing my scholarship. The last thing I'm going to talk about very, very briefly is about what it would mean if you really were to adopt law as rhetoric as the thread that ran through the fabric of your entire professional life. And I've come up with another 3 things that I think that you can do with rhetoric as a thread that goes through the fabric of your professional life. First, I think rhetoric works as a study of legal texts and legal arguments. Classical rhetoric, contemporary rhetoric give you tools and approaches that you can use to read, analyze, interpret, and criticize a bunch of legal arguments. Then I think you can use rhetoric, as we all have done, as a process for composing legal arguments. New rhetoric, classical rhetoric, contemporary rhetoric, They all give you ideas for inventing and imagining and composing and arranging and putting the right style on your legal argument. And finally, and to some extent I think this may be the most important thing rhetoric does, rhetoric gives you a perspective or a lens that allows you to look at something and say, why is it that way? Why is it not another way? So it allows you to come up with unique arguments. It allows you to reconfigure storylines. It allows you to come up with new ways of framing problems. And the simple fact that you look at something and say, okay, this is the appearance, what's the reality, which is which is a basic literary criticism technique. What's the appearance, what's the reality? If you look, as Kenneth Burke says, you turn something around and you look at all the different ways in which it could be viewed, all the different metaphors that you could use for describing that concept, it is a very powerful, creative, and imaginative tool. And that's the last way that, in which I think rhetoric really would help us integrate our teaching, our service, and our scholarship. So, with that as my final point, we will move the conversation on to the other Linda. And since I got to Mercer, I have always been known as the other Linda, so it's a pleasure for me to be able to say, but here, we will now turn to the other Linda. Well, as Linda number one introduced, I'm Linda number two, and my part today is to offer a few thoughts about two topics: some of the purposes of our scholarship and how we might think about our scholarship as a shared enterprise. Now, we know that we're talking to a room full of people who already know the value of scholarship. Of course, not everyone in our community would agree with that. As we see on the listserv periodically, we have a number of different audiences, or a number of different communities represented, or voices within our community represented. So I want to take just a second to talk about a couple of the most important reasons why we need to write. Some of these reasons are the same as any other academic writing, and some are a little specific to us. Scholarship is expensive. It takes significant institutional and personal resources. For legal writing professors, these personal resources, the cost can be especially high given the exceedingly heavy teaching loads that so many of us carry. So why should we write? We need to be clear about our purposes there. Maybe the most important purpose, and I hope that I'm not being too grandiose here, is the advancement of human knowledge, a pretty fundamental, basic reason that humanity needs to understand as well and as fully and as deeply as possible. Of course, we owe that obligation to a couple of particular constituencies in law practice, judges and lawyers. But these instrumental uses for advancing knowledge really don't quite tell the story. We owe that obligation to humanity itself, because humanity itself often advances in unpredictable ways simply by coming to understand more fully and more deeply the most amazing little pieces of our experience of life. We in the Academy are optimally situated to discover new information and to make those new kinds of connections. Now, we might be tempted in a legal writing world to think that this responsibility need not apply to us, because other professors who are not as busy as we are can fulfill this responsibility. But this is not a satisfactory answer. First, many non-legal writing professors are at least as busy as most legal writing professors. Just as busy as I can imagine possibly being. Are they going to be exempt as well? Are we going to relegate the pleasure and obligation of expanding human knowledge to simply those with leisure time? If we do that, then I submit that some of the best minds will be taken out of the game. And humanity's understanding of the world in which we live and of ourselves will be the poorer for it. Second, and more importantly, scholarly contributions are not generic. Legal writing professors have a unique set of experiences, a unique perspective, and a unique set of skills.
Some contributions will be made only by legal writing professors. If legal writing professors are not writing, then those contributions will simply not ever be made, and we'll be making a decision to forego that, to forego understanding those kinds of things. That would be a significant loss. Another important purpose of scholarship is the enhancement of teaching, of course. We know that if a teacher knows more, that teacher can impart more. Certainly that's true. But that simple correlation really doesn't fully describe the reason that writing enhances our teaching as legal writing professors. The most important reason we need to write in order to enhance our teaching is the discipline, Chris, there's that word again, of doing what we expect our students to do. It's easy to forget how excruciatingly difficult writing can be. Do I hear an amen from the students in the back of the room? How frustrating it can be to try to master a new subject and then present that new material in a logical way. How intimidating it can be to expose oneself in print. I hope that's not a metaphor. We can forget how confusing and disorienting it is to write a new language or voice, or in a new genre, Chris, or to a new audience. If we ask our students to do these things, can we ask anything less of ourselves? Tennis coaches play tennis. Cooking teachers cook. For the same reasons, legal writing teachers should write. And this rationale, by the way, doesn't mean that we should write office memos and briefs, right? That might be a tempting kind of a conclusion to draw from this, but ultimately it misses the primary value of our writing, that our writing can have for our teaching, because most of us can write an office memo or a brief really easily, right? By now, we can just do that almost in our sleep. So we miss the experience our students have if what we're writing is simply limited to the genre we teach. Most of us have to work a lot harder to write a law review article, and we experience a lot more intimidation and confusion and insecurity and all of those feelings that our students feel every semester. So the greatest teaching value for our writing is experiencing again the kind of difficulties we ask our students to experience every semester. For us, we need to be writing the things that stretch us, the things that are not the most familiar genres. Okay, another reason. We can't leave this subject, I hope, without, oh, by the way, there was one reason I left out, but after Chris's talk, I have to at least just state it, which is our scholarship is the best way we have of speaking truth to power. Speaking truth to power. And everybody in this room particularly on the first 4 rows, know exactly what I mean. So I won't say anything more about it, but that's really important and has served us well. Okay, and finally, scholarship can be personally and professionally transformative. This kind of transformation has value beyond the scholar's own transformation. The best teachers are curious, constantly learning, adapting, intellectually engaged. I look out at this audience and I see face after face that these words describe. And students and judges and the rest of us are so well served by the work of that kind of transformative scholarly enterprise. And I've been honored to be the recipient of so much of that important work that the people in this room have done. I think actually, although that transformative power applies to all disciplines or academic areas, it may be that we as legal writing professors need it the most. Why is that? Because legal writing professors in many places teach nothing but legal writing 1, 2 sections, legal writing 2, 2 sections, year after year after year, when non-legal writing professors generally teach 3 to 4 different courses every year. It may be that we are the people who need to do scholarship in terms of personal transformation and professional transportation more than anybody else in the academy. We need to be experiencing the excitement of exploring that new intellectual territory and seeing where it could lead us, following us everywhere it could go. Okay, these internal purposes provide all the justification we need. Ideally, these are the reasons that we will write. But of course, we have one external reason that we need to mention, right? If we're ever to achieve equal status, full membership in the academy, we'll need to be both good teachers and good scholars. The hard reality is, if we are subject to reduced professional expectations, we will always be subject to reduced professional status. That's just the way it is. Yes, scholarship is hard. It takes significant resources, but even for legal writing professors, its purposes are more than worth its costs. Okay, so if we're going to do scholarship, how should we think about what we're doing? And here I hearken back again to Marilyn and Carol and Chris, who've already spoken today about the communitarian nature of what we're doing. And I want to talk about scholarship as conversation. If scholarship is a responsibility we owe in part to others, and it is, it can be easy to forget that it's a shared project. It's usually done alone. I think Marilyn mentioned that first, right? A writer at a keyboard thinking and typing great thoughts. To that writer, it feels like speech making. She has an idea. She's going to present it, standing up metaphorically in the community of scholars. She's going to sit down to great applause. End of project. Isn't that all what we all want? Right? We all want that. But in fact, everything that we write is generated from a body of ongoing work by others. It will be presented to others to become a part of that shared discourse that's inherited by everyone who comes after us. So instead of speech making, let's think about conversation. Imagine a room full of people in animated conversation. The door opens. A professor, let's call her Professor Henderson, walks in, right? How can Professor Henderson and the rest of the people in that room help advance this shared project that the group is there struggling to try to understand some kind of hard question? Well, she should first sit down and listen for a while, right? And maybe she should lean over to the person beside her and say, what has been said already? What did I miss? She should find out who's saying what, where the direction is headed, what it's already covered, what the positions that have been stated already are. Once she has a good idea of what's been said already, she should start to participate. When she gets to stand up and to make her point, she should try to say something new, right? It would be kind of silly if she stood up and said, well, X said this, and Y said that, and Z made this other point, and then sit down, right? That would be kind of strange behavior. So she needs to say something new, because when she stands up to talk, she makes an implied promise to her listeners that she's going to be a good steward of that conversational time that she's taking up, of their time in listening to her, that she's going to move the conversation forward somehow. But of course she should also mention what's been said already, because she needs to connect her new ideas to the threads of the conversation that have already been said. Okay. What duties do the other people in the room have? Do they have some kind of responsibility to this ongoing responsibility? Well, certainly. They have the duty to listen to her with an open mind and an open heart, hoping, anticipating that they will learn something new, willing to be persuaded of something they didn't necessarily think before Professor Henderson started to talk. They need to be happy to have a new voice entering the conversation, instead of wondering who this strange person is who came into the room. They need to welcome her into the conversation. Maybe they should be willing to tweak her idea. Maybe they even should be willing to disagree with her idea, sort of a remarkable idea, disagreeing. We'll talk more about that in just a second. Because after all, they're in a shared project of searching for the best answer. So let's say, maybe, that somebody in the room doesn't exactly really agree with Professor Henderson. We'll call him Professor Brown. Does he have an obligation, perhaps, to, at some appropriate point, share his perspective with the group, disagreeing respectfully with Professor Henderson? Yes. Yes, because what if the best answer the group would have been able to come to is somewhere in between those two perspectives? What if it's somewhere on the other side of Professor Brown's perspective? The group might not ever get there without all of those voices participating. We've all shared good group deliberations like this, right? Good faculty meetings proceed exactly this way. We have all participated in a few good faculty meetings. I certainly have. With this kind of full, thoughtful, broad, respectful participation, all of the participants come away learning a great deal more. They understand that topic much more deeply and fully than any one of them ever could alone. Okay, so I think this model works pretty well for our scholarship. So how are we in the legal writing world doing with the criteria that have been implied in this discussion? The first is thorough research. Well, I think our articles, generally speaking, are pretty well researched. We are good researchers ourselves. We generally teach that skill, and usually our articles tend to show those skills. We do have to be careful, though, to continue to do what Linda, number one, has said we're beginning to do, and that is to reach out beyond our own discipline. Not only reading the Legal Writing Journal and J. Allwood, not only reading the second draft, not only reading the JLE articles that have come out of our community. We have to reach out into other disciplines, other voices, other rooms, to begin to make the connections between our work and the work of scholars who might not know about us, right? Because if we want to be full members of the Academy, we have to start with our scholarship. We have to start making those relational connections in the work we do and the work others are doing. It's also true that there's fabulous work going on out there outside our own discipline, and we'll be the better for it if we want to rely, if we can rely also on that other work. Okay, are we making new points, relating them to old points? Generally speaking, yes. Every once in a while we don't do such a good job. Every once in a while we announce an idea as if it were the first time anyone had ever thought of it without realizing that, in fact, Chris wrote about it, 20 years ago or whatever. But most of the time we're doing a good job of coming up with something new but relating it to the older work, the foundational work in our field. How are we doing at welcoming new scholars into the shared conversation? Are we glad when they make new points that we haven't thought about? Almost always, yes. Our community is one of the most supportive academic communities anybody could ever hope to find. Of course, and let's just be honest here, even an established scholar can have a twinge of proprietary emotion when a new voice enters the conversation, right? But as members of this marvelous community, we always put that little twinge behind us and welcome that new voice into the conversation. I think that's exactly what Mary Lawrence taught us to do and has been continuing to remind us to do all of these years. Thank you, Mary. Okay? But our collegiality, I want to say, occasionally gets in the way in one way. It is hard for us to disagree with each other, especially in print. Okay? It is hard for us to disagree with each other in print, and for some understandable reasons. Terry Pollman may talk a little bit about this. There you are. She refers to it as the provocative voice. The provocative voice is not always encouraged in our community. We're reluctant to disagree with each other, but mature disciplines aren't afraid of disagreement. They have to struggle sometimes to disagree with each other respectfully, but they learn how to do that. And we, I hope, will be learning more and more how to disagree with each other and still be the kind of supportive community we need to be. Now, of course, in a marginalized community, disagreeing with each other is complicated, particularly if we do it publicly or in print, right? If Professor Brown wants to disagree with Professor Henderson but Professor Henderson is on a tenure track or is working toward a long-term contract. How should he feel about that? Should he refrain from disagreeing? Should he keep back those points that he might have wanted to make out of concern? Well, certainly we hope he is sensitive to audience, right? We're the rhetoricians in the Academy. We need to be very sensitive to audience. And as I think Terry is going to talk a little bit more about in just a minute, in a sense, we have, like all marginalized communities, an inside audience and an outside audience. And whenever we put anything into print, we have to remember that. We have to remember that we're writing inside and outside. So we need to write in a way that is sensitive to the possibility that a reader from outside the community might misunderstand our point. You know, other areas of scholarship in the Academy thrive on disagreement. The kinds of substantive disagreement that would be accepted as a matter of course can, in marginalized communities, be interpreted by those from the outside as being something much more serious, especially if the readers are people who are not yet convinced of the clear equal status of legal writing. So we have to honestly write. We have to share our disagreements with each other, but we have to do it in a way that makes it clear our respect for the work of the person we're disagreeing with. After all, that work is so important that it's necessary for us to actually engage it seriously. So that is a very delicate rhetorical balance that we have to engage in. But I hope that the next generation, the next leap, I'm lost. I don't know what metaphor we're on now. Will help us to do that. And I just want to say one more thing about that the value of an article is not really a question of whether I agree with it or not, or whether someone else agrees with it or not. Some of the most important work in a discipline actually calls into question all the commonly held beliefs and assumptions everybody has. And if the work is well researched, well presented, and filled with creative insights, it deserves high praise as a separate matter from whether a particular reader happens to agree with all of the points that are made. So I think the future of our scholarship is exceedingly bright. We're making big strides. We're deepening and broadening our understanding of our discipline. We're citing each other more. We're reaching out beyond our community and citing other areas more and making those kinds of intellectual and scholarly connections. We're learning to support each other. I hope more and more we will learn to support each other while we disagree from time to time. I can't think of a better time to be in the legal writing world or a better community in which to be doing scholarship. As Linda number 1 already said, philosophy has long since turned to the study of language. Jurisprudence has unseated the theoretical underpinnings of routine case-crunching scholarship. This is our time. This is our time, and I can't wait to see what we do with it. Thanks.
Hi, I'm not Linda. Right now I wish I were either one of them because they both do such a good job. I'm going to talk a little bit about audience and about writing what I like to think of as for our most demanding selves. So identifying an audience is a complex question for any scholar in the legal academy or elsewhere, but especially I think for legal writing scholars. I began by doing a little bit of research on audiences that legal scholars write for, and there's a big debate. Some of you will remember in the 90s, Judge Harry Edwards wrote a piece about how legal scholars were not writing enough doctrinal scholarship. It was the age of the law and scholarship, and he was dismayed that they were not writing, that they were writing for each other and not for judges. So there are many who maintain that the proper audience for scholarship is judges, and that legal scholars should be eager to do scholarship because this is how they change the law, a direct connection to the law. Others say, no, our connection to changing the law is sufficient because we're writing for other scholars. In doing that, we shape the legal academy, we shape the education of a next generation of lawyers, and that's how we shape the law in our conversation with each other. There was an article that I especially liked by Erwin Chemerinsky and Catherine Fisk that argued that we should look beyond these two audiences to many audiences. It wasn't just judges or other scholars, but there were lots of people that we should be talking to through our scholarship. I found it telling at that point to say that, to tell myself, that when Linda Edwards and I sat down to talk about this panel, we didn't talk about judges. We didn't talk about scholars in whatever area. We talked about the inside audience and the outside audience. We didn't see beyond an inside audience and an outside audience. We were so conditioned by years in the legal writing community to think in a we-they position that was our question about audience. And so I'm going to talk a little bit about this inside audience and outside audience. I think that's my metaphor, is what does it mean to be inside and what does it mean to be outside. The inside audience is composed of other legal writing professors. The community ethic is extremely strong, and we expect and have come to enjoy this high value of uncritical support and unquestioning acceptance. We all clap for each other very loudly. The outside audience, in contrast, are made up of other law professors on the faculty and especially tenure committees. Right? Those are the outside audience. And we see them as critical, adversarial, and that they may threaten job security for many of us. The rewards and the dangers posed by that outside audience are real. They're not, these are not phantom fears or imaginary threats. They're real threats. And that they thinking can be stultifying, but I don't want to minimize the dangers that we face when we talk about whether we write for the outside audience or not. But I also think this fear of the outside audience, or this fear of, let's say, the critical audience, can be so destructive. For many legal writing professors, it simply means they don't write. They reject the whole enterprise. They already have enough to do. There are probably a lot of reasons legal writing professors sometimes don't write. We all know that after grading 34 papers 4 times a semester, it doesn't leave a lot of time for writing. We all know that many of us need summer teaching money to make up for lower salaries. So there are, the labor-intensive nature of what we do, there are plenty of reasons why we don't write. But I do think it's the fear of criticism sometimes that holds people back. And it creates a really paradoxical situation in that, again, we have writing teachers who don't write and who don't believe in the value of writing. So that it reminds me most of, I think we all know faculty members who come to teaching because they don't like law practice. And they get in the classroom and their disdain for practitioners shows. And I think that's damaging for students, and I don't like it. But I think that's the direct analogy to those of us in the legal writing world. And you see it on the listserv at least once a month. It's people who talk about legal scholarship, minimizing its value, saying nobody reads those articles anyway. They don't have the influence that I have in my teaching, and reject the idea of writing completely. So I think that's one aspect of the outside audience and the critical audience that has stunted the growth of our community. Okay, other legal writing teachers do summon the fortitude to write, and they're faced with these important questions about which audience to write for, of our two audiences. There are dangers in writing for both. The dangers of writing for the outside audience. One of the dangers is that I believe legal writing teachers are faced with even more of a dichotomy between inside and outside than others. And that's because when the torts teacher writes and has to decide whether he's writing for the torts audience or the general academy or for judges, everyone that the torts teacher is writing for had a good basic torts class in their law school education. The people that we are writing for, many of them had poor, if any, legal writing training. They don't have the vocabulary, they don't have the basic foundational education in rhetoric and communication that are required to read our scholarship. So sometimes they're not a very good audience, right? Okay. The other danger is that if scholars decide to write for this outside audience, in addition to the dangers of the audience maybe not understanding them very well, we also have the question of topics. When Linda Edwards and I did the bibliography a few years ago on the scholarship produced by professors who self-identified as one of their primary areas of interest was legal writing, much, if not most, I can't remember this slide, I think it was 75% of the writing was on other topics. And if we write to please that other audience, that directly contributes to stunting the growth of our own community. So that's another problem. But there are also difficulties in writing for the inside audience. Let's see. One risk is that we may be writing for a smaller and less influential audience. I think that is changing. Whether we look at our journals, our own professional journals, whether we look at the number of legal writing topics in general law reviews, whether we look at symposia like this one, it's clear that we're making inroads, but it's also clear that there are many in the legal academy who would not take the time to read a legal writing article. So we worry a little about that if we write only for ourselves. The other problem lies in that ethic of support and non-confrontation that Linda Edwards was talking about. If we write only for ourselves, it leads to the suppression of that provocative voice that if we're going to write for this very supportive community that's pretty much afraid to take each other on sometimes, then we're going to limit ourselves. It's not going to be someone else limiting the topics and the ways that we grow. It's going to be a self-limitation, and I worry a little about that. So, if there are troubling aspects to choosing between an inside and an outside audience, there are also problems, I think, with continuing with a we-they thinking about audiences generally. Most salient is just the limitation in the way we think. We're torn, sometimes paralyzed with choosing between the two audiences when there are many more out there. Most obvious is that many legal writing scholars miss the chance to think about influencing judges and practitioners. We do write for judges and practitioners. Ruth Ann's article on visual presentation of briefs is on the website of the Seventh Circuit. Kathy Stanchi's article on confronting adverse authority, any practitioner would learn from and do learn from. There are numerous articles on weight of authority or on unpublished citation that are, we do write to these other audiences, and I don't want us to forget that we do. I think another interesting phenomena is that when judges write, they often write about legal writing, whether it's Judge Alazard or whether it's Justice Scalia. Yeah, I mean, he's gotten kind of a bad rap today. Well, he deserves a bad rap sometimes, but he's gotten kind of a bad rap today for saying there's no such thing as legal writing. I think, on the other hand, he's written a book with Brian Garner about legal writing. He's written an article. Judges care about legal writing, and they're a natural audience for us. So I don't want to forget that audience. So I think that in some ways it's important for legal writing scholars and this new generation of legal writing scholars to think about putting the we-they audience, the inside-outside audience, aside and not letting that limit our thinking as much as it does. Now, maybe the exception is when you're in the tenure process, you might want to think about them, but on the other hand, I kind of hope we would reject that choice. And there are some other research and some other scholarship within our discipline that suggests to me that perhaps the audience we're looking for is the individual audience, and it might be that we should be writing for ourselves. And what I've been thinking about with this is the research on audience and motivation. There's a lot of theories of motivation. You know, it goes back to Abraham Maslow and his hierarchy of needs, and there's incentive theory, and there's cognitive dissonance theory of motivation. But the one that has sort of captured the imagination in the legal academy is the extrinsic and intrinsic motivation theory and debate. Most of you will be familiar with it from, why am I going to forget his name? Larry Krieger and the humanizing education folks have really picked up on the intrinsic and extrinsic motivation theory and linked it to self-determination theory to talk about how if you are motivated internally by extrinsic I'm sorry, I'm going to blow this up the whole time. By intrinsic motivation, internal things. If you're motivated by curiosity, by your own satisfaction, by something that you want to do, you learn more deeply, learners learn more deeply, you work on things longer, you take greater satisfaction, and it's pretty much unquestioned that you have better success. If you're motivated by externals or extrinsically motivated, then you're motivated by things like money or status or tenure. Those are much more difficult things to accomplish. It turns out that people who use externals for their motivation end up disinterested in the task. That's the most often result. And I think that you see that even, outside of the legal writing community. That's on any faculty. That's the new faculty member who comes in excited about teaching, and at the end of the tenure process with this external motivator hanging over their head, never want to write again, and some of them don't. So I do want to say, many in the legal writing community have written about this. Sam Jacobson wrote about it. Emily Zimmerman's done a huge article, Nancy Stolenhoff. Who else? Terrill Wallinger at Camden Rutgers, thank you, has written about it as well. So I do want to say that I think we should think about a little bit about that internal, intrinsic motivation and what it might do for us. Before I finish today, I want to talk just a couple more minutes. We wanted to leave lots of time for questions, so I'm going to try and do this quickly. But just a minute or two about using audience to advance the community as a whole. And I think there are two important habits that we can do there. One of them is that I have the sense that we don't read each other as much as we should. And I think a part of it is personal. I joined the board of the Legal Writing Journal last year. And reading everything that comes in, I realized how much I was not reading beforehand. And I think it grows out of a couple things. I think we've had such vibrant national conferences and frequent conferences that we have become used to that conversation that Linda Edwards talked about happening every year for us at a conference, or every other year for us in a conference. So we do that through presentations, we do that through the listserv, and we don't rely enough on reading and reading and citing each other and building on each other. And the other relates to what Marilyn talked about this morning. And I've had occasion on my own faculty and within my own family now. My daughter is looking for a teaching job, and she's currently teaching legal writing this year. And she's in this whole process of learning to do scholarship. And I have watched her and her friends, and they do just what we teach our students to do, but I'm not sure we do ourselves. And that's a peer review process that begins very early in the writing process. I've watched junior faculty members at 3 different institutions come in and start with a draft that honestly a legal writing person would be embarrassed to show anyone. It's horrible. And they pick 2 or 3 people. I don't know why I'm such a sucker that I'm always on the list. But 2 or 3 people that they trust not to judge them on the basis of a bad draft. And it starts there. And it goes in sort of concentric circles out. And each time, there are people that they know a little less and trust a little less to not to judge them. But each time, the draft gets better and better and better. We watch our students do that. A lot of legal writing people I know think they've done that if they show their finished draft to one person before they send it out. We don't start with a bad product and go through draft after draft with people we trust to make something good. And I'm telling you, these drafts that our students would be embarrassed to give us as a 0 draft end up published in highly prestigious law reviews and are terrific pieces. We know how to teach people to do this, and I just think it's time for us to start doing it more ourselves and using the process a little better. So I want to end by saying that most of us came to teaching because we love to learn, and that a synonym for scholar is student, and that the way that you learn, we all know this, is to write. And it seems to me that it's been wonderful to watch in the last 25 years at the Legal Writing Institute how we have built a discipline by writing and shown our love to learn by writing. But I think the next 25 years will be even more full of it, and I look forward to it.
I'm actually not going to stand unless you need me to with your camera. You don't need me to? Great. So do we have questions? Yes.
One of the things, the we're all nice to each other issue and the provocative issue is something that I think is affected by gender. And it's affected in a couple of ways. One, it could be affected by our stereotypes of women supposed to be nice. But the other thing, and I say this as someone who, like probably most of us in this room, have written tenure letters. And I was instructed when I wrote tenure letters, be sure to be critical in the letter. And this is something that women are told to do and men are not frequently. And Eric is making a face, so apparently he was told. But I think that it is, if the community that is the source of the letter, and that's my phone, I'm going to ignore it. If the community that is writing the letter is, it's got about 3 more rings. If the community that is writing the letter is seen as being too inside, and this is if you're a person of color who's getting letters from another person of color, if you're a woman who's getting a letter from another woman, if you are a legal writing person who's getting a letter from another legal writing person, well then, well, of course they're not going to say anything critical. They're all friends of each other. And for us, it's true. We are all friends. And so it is something I was told, make sure you say something critical. And one of the times I said something critical, the person did not get to it. And I don't know. I wasn't in that meeting. So I don't know. Did they quote my letter? What did they say? So I guess I'm going to ask the panelists to comment on that sort of, and as you said, this is not a fake problem. This impact of being critical of each other when we are a marginalized community, it's a real problem. And I guess the other thing I'm thinking is, what a great topic of scholarship. How to be critical and respectful. And I'm just going to extend my question just a little bit more to cite Ron Clark. I don't know if this is Georgia, so I don't know if people know Ron Clark more. The guy who was the big Disney Teacher of the Year, who has started the Ron Clark Academy in Atlanta. And I actually read his book on teaching, and I found a lot of things relevant to our teaching. But the one thing I remember is that he was teaching his 5th graders how to have the kinds of conversations that, I forget which of the Lindas was talking about, which is person number 1 talks, and then person number 2 says, well, here's how I feel about what person number 1 said. I agree with this, or I respect it, or something appropriate and respectful, whether you're agreeing or disagreeing, and then taking it to the next level. So what is a way to be provocative? What is a way to be argumentative but still respectful in an effective way? I mean, I think that would be really neat to write about. So, but I asked for your comments about our sort of insular issues.
Anything? Well, you know, I think that in order to advance as a discipline, we actually do need to engage with the ideas that are in our work. And that involves, I think, criticism. But I think that to some extent, if you can criticize, I mean, this sounds like a mom, you know, criticize the idea, but not the person, or talk about an alternative way of looking at the idea that doesn't really say, and that person didn't do this thoroughly. I think those are some of the approaches that you might take in your scholarship responding to somebody else. In a tenure letter, I think, you know, the experience that we've all had, the transcript is running, right? The experiences that we've all had, we know that criticism is very harmful in tenure letters, and that's where I'm going to leave that.
Okay, my faculty is one that doesn't take a letter seriously unless there's criticism in it. And I think that you have to be obviously very, very careful. And I also think that the other piece of that is, I don't want to, the other piece of that is that I'm being asked to give my opinion. And I'm willing to look for positives hard, but I am not willing to say something I don't believe.
I think that going back to these 2 different audiences, which you know, I set up so well for Terry to be able to say why we really shouldn't be thinking that way, and it's true we shouldn't eventually. But I think, first of all, I'm not willing to say something I don't believe either. But now that I've defined that, within that world, I need to be able to remember that if a torts article is being evaluated in a tenure process, most faculties will expect that that evaluation letter will have some critique, something or several somethings that the writer of the letter thinks could have been done differently. That will be expected as a matter of course, and a certain amount of that will make the letter more credible in the praise that it gives, in that context, with that audience. But what I hope, what I'm trying to do is to write a letter that will be apples and apples, that will equalize that process of reading my tenure letter, so that it is very clear that, if it's true, it's very clear that I am disagreeing as a matter of substance, but that I am still able to see nonetheless the real value that this work has for the advancement of our discipline. And that ought to be the operative question. So, of course, leave it to Mary Beth to ask the hardest question that could possibly be asked here, especially with the transcript running. But it's just such a hard balancing act. I think fundamentally we can't be dishonest. I think fundamentally we owe it to our own discipline and to the academy in general to be honest. But I think we also need to remember that readers are very different. And we need to write to the audience like good rhetoricians. We need to write to the audience that is going to be reading our letter.
So I guess I don't know if this is a question, but just comment about, how much I agree with the thought that we really do need to have a conversation and in which the conversation may actually say, I disagree with you, and I'll give you an example of somebody who should have come right out and disagreed with me, and that's Ken Chestek, should have disagreed with an article that I wrote with Brian Foley and didn't. He did it so subtly that it took me actually sitting down and teaching it to my students to suddenly realize that a point he made, which was actually a criticism of an article I wrote, he was right. And I've been teaching it wrong for the last 3 years. I had to go in and say to my students, I'm wrong. That the whole story does not happen in the statement of the case. The story, actually, the arc continues over through the legal argument. So that part of Fiction 101, that's wrong. And look, the transcript is running. But I wish he had come right out and footnoted and said, here's where I break with Foley and Robbins. I would have paid more attention, and my teaching would have been better, and my students would have learned it better for the last 3 years. So I did call him up and yell at him. We're not.
Mary.
Also, somewhat of a comment on something that Terry said, and I think it's so true. You talked about your daughter and her friends who start out and they vet articles, and I see that in our faculty, our young faculty come up with an idea, and they're ready to vet it. And I'm thinking, where are you? But I think some of that has to come because in some ways we've been defending that we're even a discipline for so long, and we're supposed to be writing gods, otherwise anyone can do this. And so why would we, really the writing god would come up with the perfect thing on that first draft. Now, like you said, it's very against what we teach, which is all process, and you have to go back and back and back. But I think that's part of it, and I guess one of the reasons I wanted to make the comment is that the writing groups that have begun provide that safe environment, because maybe you don't want to go to other people on your faculty and let them see your warts.
But the last place you go is your faculty.
But if you go to other people within the safe community, and I guess that's the rub, is there's a time to be the safe community, and then there's a time to criticize and comment, and I think that's maybe one of the things we're moving into, is finding kind of the balance there. But I think I do see that in the young scholars, though, is that I have an idea, let me show you.
I think related to what you were saying, one thing, being a young professor myself, only my second year, but coming from actual practice within a courtroom or dealing with other attorneys, we're used to criticizing other people's arguments all the time. That's what we do, and we do it in a professional way. And so listening to the three of you speak about how we need to be critical of each other, I don't think I even realized that we weren't in this community. And so I think that maybe there is something that can be learned from the newer teachers that are coming in from a real world practice, that there is a very professional way to say, I really respect the way that you thought about this, but here's how I think about it. And respectfully disagree, and I do think that it's very helpful.
Kirsten.
I was just going to say from the journal editor perspective that I think this is exactly what we're facing right now, and those of us that are on the editorial board of the journal, both journals, know that we receive a lot of articles. And I think that there are several young scholars, and maybe even not so young scholars out in our community, who feel like if I write an article and I send it to Jay Owlett or the Legal Writing Journal, they need to publish it. They need to help me grow as a scholar. And we are in a position where, we received, 60 articles this year, I think? About 60 submissions, and we have given offers to 8. We turned down 52 authors, some of whom I know are very upset that we did not find their articles worthy, in their words, of being published. And so I think that's part of where we are right now, and I'd love to hear what the Lindas and Terry have to say about this. How do we balance our mentoring roles with the idea that we do want to further the quality of our scholarship and not publish, and not to say that we used to publish garbage and now we only publish, not to say that, but the discipline has matured and the bar has raised. And how do we still mentor young scholars but yet have this increasing level of quality and increasing level of conversation in our two journals?
I'll answer that in a minute, but I was also going to just say something about what Elizabeth said, which this morning I was thinking about legal writing as feminism, and just a minute ago I was thinking about legal writing as battered woman syndrome because of the safe community idea. And I think that Elizabeth's onto something there with, I think that people who have not been in legal writing for 25 years are not going to feel the same obligation to support each other and each other's ideas all the time. On the nurturing or mentoring aspect, I do think that a number of efforts that have gone on, the Legal Writing Institute workshop, writing workshop, the Allwid Scholars Forums and workshops, and the fact that a number of regional conferences, not just with Allwid Scholars Forums, but apparently now there's a number of the regional conferences that are doing this on their own. I think those are things that will help younger scholars improve their scholarship. And I think we also, as members of the editorial boards, I think we also end up doing a lot of mentoring ourselves, and I think that's a good thing. It's time consuming and we have a lot of other things to do, but that's probably not a real answer, but that's what I'm thinking would help.
Well, it's another way scholarship informs teaching is, there's nothing like getting your own article back with comments on it to let you know how your students feel.
I think the best thing, the quickest way to make a difference on that topic is for every one of us in this room to say at every opportunity when our community meets, including electronically, every now and then on the listserv, if you haven't had your draft reviewed by other colleagues at least 10 times, or pick a number, whatever, don't send it to a journal yet. It's not ready to go. I think if that statement becomes a part of our shared common wisdom because everyone in this room has repeated it, that people will start to do that. I think the people who don't do it, there are complicated reasons why they don't, but part of it is they just don't think about doing it. They think that once they have a relatively decent draft, they're done. And getting to the relatively decent draft has been so hard that they hope they're done, and they want to send it in. So I think just repeating that simple message would do a lot.
I should say also, for proposals for conferences, do the same thing 10 times before you send it in. It's getting much more competitive for those two.
I was just going to say, in relation to what Kristen was saying, is that one of the things the peer-reviewed journals do that happens in other disciplines all the time, but is only confined to our peer-reviewed journals, is that a young scholar does get a tremendous amount of feedback, or a more mature scholar, whomever, you get a lot of feedback that when you do submit that article elsewhere, it is much better for it. I think the question is the willingness to accept it. Craig has had his hand up over here.
Throughout this conversation, the word that comes to mind for me is constitution, or maybe as a phrase, scholarship constitution. I think there's a lot to be said here, and it's interesting how much even people with a lot of expertise here have to discuss how there are generational differences, how all of these questions change over time, because if you're not quite so marginalized community, or we have such differences in, this school compared to my school in legal writing is a world of difference. Mary Beth's giving the visual cue. and that makes it difficult, and I just wonder, Do we have a constitution of that sort or something that plays that role? And if not, do we need that?
Best practices.
Yeah. Well, we're writers of the Constitution, but when Linda and I were first talking about this is really going to date me. But I can remember one of my grandmother's favorite TV shows was Carol Burnett. And when Carol Burnett ended the show, she would do this thing where she would pull on her ear to tell her mother she was fine. And every show she would do it. And we were saying there ought to be some like signal we could give each other that says, I'm going to criticize your article, but I still love you.
I want to tag on to something that Kristen said, and you, Kirsten. We also have seen sort of a phenomenon. I don't know if this is happening with Jay Alwood, but we have had some young scholars, and we've accepted the article, but we've wanted revisions. And revisions that, collectively a mentoring process had gone on. And we get told, I got it accepted in a law review, and they're not interested really in any revisions. Bye-bye. And so we have to sort of get a message out also that there's an opportunity, I think, for mentoring. And I was wondering if Jane Allwood had that experience, and also wondering if you had any thoughts about how the journal we may address these issues. And maybe they're super.
Yeah, and I think Kristen and I talked about this a little bit a couple of weeks ago. I think we had similar issues where people would tell us either that or that their school valued the student-edited law review more than the peer-edited journal in the field, and including the one situation that I thought was among the most interesting. Although after it was explained to me, it made a little bit more sense. There was a school which would not give an author a scholarship stipend if they published in a peer-edited journal. They had to publish in a student-edited journal. There's some rationale for that, but it doesn't matter. I guess I think that's, and I think that there's a number of things that we can do as a community. I think we need to convince deans and faculty faculty promotion and tenure committees and all of those folks that this is a good placement, and we need to convince the authors that going through the peer review process is going to give them a better article. And maybe we should start talking about how when we went through the peer review process, we ended up with a better article, because I think almost all of us did when that happened. And those guys are trying to make us quit, aren't you?
Well, I just have a little announcement.
Oh.
This 25th anniversary of the Legal Writing Institute is a memorial. So the members of the Law Review have a special treat for you outside, and it's about break time, so if you'd like to go out and see what we have, and we can continue discussion after.
I'm happy to wrap up. They're looking at me like I should decide, so I will decide. We will wrap up and head out to see what the surprise is. Great.